Hello and welcome. We make promises all the time, but have you ever stopped to think about what actually turns a simple promise, maybe even just a handshake, into a deal that the law will actually back up? Well, today we're going to pull back the curtain on Indian contract law and figure that out. Let's get right into it. So, let's start with the big question right off the bat. If you make a verbal promise to someone, a friend, a client, anyone, is your word on its own enough to make it a legal contract? You'd think so, right? But as you might have guessed, the law's answer is a little more complicated than a simple yes or no. To really get to the bottom of that, we first have to understand what the law even thinks a contract is. See, it's not just any old agreement you make. There's a very specific definition we need to start with. And here it is, straight from the Indian Contract Act of 1872. A contract is an agreement enforceable by law. Now, that word, enforceable, that is the absolute key. It's the magic ingredient that means not every promise you make can actually be taken to court. So why does any of this matter? Well, think about it. The whole point of contract law is to bring some certainty into our lives. It gives us a framework, a set of rules that makes our agreements predictable, so we all know what's supposed to happen if someone doesn't hold up their end of the bargain. So how do you know if your agreement has that legal muscle? It's really all about checking off a few key boxes. Think of what's coming up next as your essential mental checklist for pretty much any deal you ever make. Here they are, the 6 essential ingredients for a valid contract. We're going to break each of these down, from the first offer and the final yes, all the way to making sure everyone involved is legally allowed to make the deal and is doing it willingly. If you miss even one of these, your whole agreement could fall apart. All right, let's start with the absolute bedrock of any contract. We're talking about the first 2 items on our list, because together, they're what create the agreement itself. It all kicks off with a clear offer. Something like, hey, I'll design your company logo for 10,000 rupees. Simple enough. But the acceptance has to be just as clear. An absolute no strings attached yes to that specific offer. If you come back and say, yeah, sure, but how about for 8,000? Well, that's not an acceptance. That's a counteroffer, and it actually kills the original deal right then and there. And get this, an offer doesn't always have to be from one person to another. In the classic English case, Carlyle versus the Carbolic Smokeball Company, a company basically advertised a reward to anyone who used their product and still got the flu. The court said, yep, that's a valid offer to the entire world, and Mrs. Carlyle accepted it just by buying and using the product. Pretty cool, huh? Okay, so we've got an agreement, an offer, and an acceptance. But that's not the whole story. Now we need to look at the who and the what of the deal. Who's making it? What's the price? And crucially, are they agreeing to it freely? This next part is what lawyers call consideration. Don't let the fancy word fool you. It's simply the something in return that each person gets. In our logo example, the designer's work is the consideration for the payment, and the 10,000 rupees is the consideration for the logo. Both sides have to give and get something of value. It's the legal term for what's in it for me. Next up, who's actually making this promise? The law is super clear on this one. To have what's called the capacity to contract, you have to be at least 18 years old, you have to be of sound mind, which basically means you get what you're signing up for, and you can't be disqualified by some other law. And this brings us to a massive landmark rule from the case of Mohori Bibi versus Dharmadas Ghosh. The court made it crystal clear. Any agreement with a minor is void ab initio. It's a Latin phrase that means it's void from the very beginning. It's like it never even existed in the eyes of the law. And finally, for a contract to be valid, the consent has to be given freely. But there are 5 major things that can mess this up. If you were forced, unfairly influenced, straight up lied to, or if there was a huge mistake about what you were agreeing to, well, then your consent wasn't really free, and that contract can be challenged. So what happens when one of these essential ingredients is missing? You basically end up with 2 possible outcomes. You might have a void agreement, like that one with the minor, which is legally nothing from the get-go, or you could have a voidable contract, say one where there was fraud. That one is actually valid until the person who was tricked decides to cancel it. The power is in their hands. Okay, now for the part everyone always wants to know about. What happens when someone breaks their promise? This is what we call a breach of contract, and the law has a few specific tools to deal with it. The most common solution by far is damages, which is just a legal term for money to compensate for the loss. Why is it so common? Frankly, because it's usually the easiest thing for a court to figure out and enforce. In some really rare cases, though, like the sale of a one-of-a-kind painting, a court might order specific performance, forcing the person to go through with the deal. An injunction does the opposite. It's a court order that stops someone from doing something. Right, so you sue for damages. Makes sense, but there's a limit, right? You can't just claim money for every single bad thing that happened as a result. The law has a really important rule about how far those claims can go. And that rule comes from another famous English case, Hadley versus Baxendale. It basically says you can only get money for losses that were a reasonably foreseeable result of the broken promise at the time the contract was made. So any wild, unexpected, or totally remote losses, yeah, those are off the table. It all comes down to that one word, foreseeable. Now, the awesome thing is that these basic principles we've just covered, offer, acceptance, consideration, all that stuff, they're basically the building blocks for all sorts of other, more specific legal agreements that you probably run into all the time. And you really do see these core ideas everywhere. An insurance policy? That's a contract of indemnity. When you co-sign a loan for someone, that's a guarantee. Even something as simple as leaving your car with a valet creates a bailment. Or hiring a real estate agent. That's a contract of agency. They're all built on the same foundation we've just talked about. So if you only take one thing away from all of this, let it be this. Whether you're closing a huge business deal or just starting a small freelance project, always, always run through that mental checklist. Do you have a clear offer and acceptance? Is there consideration for both sides? Is everyone legally capable and agreeing freely? That's how you know if your promise has real legal power behind it. And I'll leave you with this final thought. The next time you're online and you're about to click that little I agree button on a website's terms and conditions, just pause for a second. Because in that moment, you are making an offer or an acceptance. You are entering into a contract. And the real question is, what exactly are you promising?